Good morning. I'm Peggy Cook, the branch manager of the Shawnee Public Library and a regional coordinator with Pioneer Library System. Thanks for joining us. I'm really excited this morning to launch our Lawyers in the Library series with an awesome presentation on the subject of family law issues. Our speaker today, Aubrie Comp, is well versed in these topics. She comes to us from Legal Aid Services of Oklahoma, and Legal Aid has joined with Pioneer Library System as a partner in providing services and programs to our customers. So look for more exciting things to come. Now, this program will be posted on the Pioneer Library System's YouTube channel. There are lots of great programs on a variety of topics on our YouTube channel for all ages, but we will have more programs on legal issues and legal matters to help you, our customers. And those will all be available on our YouTube channel. So thank you so much. Thank you, Aubrie. Now, Aubrie is an attorney, as I said, with Legal Aid Services of Oklahoma. Her specialties are in family law, guardianship, landlord-tenant law, and other areas, but family law is her major area of service. So, Aubrie, thank you for being here with us today, and we're going to look forward to what you have to share with us.
Great. Thank you for having me today. I want to speak very briefly on the basics of family law in Oklahoma. Before we begin, I want to remind you that every case is different and this presentation is very basic legal information and does not create an attorney-client relationship. If domestic violence is occurring in your case, please reach out to the SAFE line at 1-800-522-7233. That's 1-800-522-7233. If you need specific legal advice, please contact an attorney to discuss the details of your case. When a person is wanting divorce, there are certain documents that they need to file. The first is the petition. The petition is where they lay out the legal issues that the court needs to address. So they will list who the parties are, whether there are children of the marriage, and what they believe custody and visitation should look like. They'll also list any information on property, debts, and any requests for child support or support alimony. If there are children, they will also need to list where the children have lived for the past 5 years. Another document they need is called a summons. A summons basically tells the other person that they have been sued and that they have 20 days to respond once they've been served. If both parties agree to the divorce, the opposing party can sign a document called a waiver, which needs to be on file at least 24 hours before the agreed decree is filed. The waiver will allow the case to proceed without service occurring on the other party and will sometimes allow the final decree to be signed by a judge without the other party appearing in court. If your husband or your wife files for divorce and you are served, you have 20 days from the date you are served to file your answer and counterclaim in the court. In your answer and counterclaim, you will need to respond to each request made by the opposing party with admit or deny, depending on whether the statement is correct and whether you agree with it. You will then need to list what you would like the court to do in the counterclaim section. You will sign your document, you list your name, your address, your telephone number, and file it into the case. You will then mail a copy of it to your spouse or to their attorney. Please do not buy forms off of roadside signs, Facebook groups, or from paralegals. These forms may seem like a great deal, but they are drafted by people who do not have the required legal training, and they may end up costing you thousands of dollars or wasting months or years of your lives trying to fix the issue they create and trying to get a divorce. You can file for divorce in Oklahoma if you have lived here for at least 6 months. You will file in the county where you have lived for at least 30 days. If your spouse does not agree to the divorce, you will need to serve them. You can serve them by certified mail, sending it return receipt requested and restricted delivery, or you can pay a sheriff or a private process server to handle the service issues. You will need to file a certificate of service with the court once you have served the opposing party, so make sure you keep the green card from your mailing. If you are unable to serve them through mail or with a process server, you will need to ask the court's permission to publish notice in the newspaper. If a child has been born during the marriage which does not belong to both parties, you should seriously consider hiring an attorney to handle the case, because the husband is legally the father under the law, whether the child is his or not. Let's say Jane and John were married in 2002 and they separated in 2003, but they never filed for divorce. Both parties meet new people and start new families. John is still legally the father of Jane's children if the parties are still legally married. This also means that John is legally obligated to pay child support on Jane's children. There is a way to remove John as the father, but it is complicated and requires a lot of steps, and it is time sensitive. Oops. Another common question regarding divorce is, how long does it take? The answer is it depends. A divorce with no minor children can be finalized in 10 days after filing if everything goes perfectly. If there are minor children, the divorce cannot be finalized for at least 90 days unless there are special circumstances and you receive permission from the court. Divorces with minor children also require both parents to attend a co-parenting course that is approved in your county and by your judge. If the parties do not agree, the timeline will depend on the complexity of the case and the issues and the court's schedule. Now we're going to move on to the issue of paternity. Paternity is a legal action that establishes who a child's legal father is. It gives the person a right to be a parent, allows the child to access the parent's Social Security benefits, inheritance, and medical insurance, just to name a few things. Paternity can be established in a few ways. The acknowledgement of paternity is often signed in the hospital when the child is born, and it legally establishes the man as the father of the child. It is very important that if there is a question as to who is the father of the child, neither party should sign the acknowledgement of paternity. The next way is through administrative court. If you open a case with child support services, they will work to establish the paternity of the child, whether through agreement or genetic testing. This method does not address custody or visitation, and it only establishes child support and paternity. The third way is through the district court. This is where a petition seeking to establish paternity, custody, visitation, and child support is filed. An order will eventually be entered establishing paternity if the man is shown to be the biological father, either through agreement or genetic testing. Please keep in mind that over-the-counter genetic tests are not reliable, as there's no chain of custody and they are not admissible in court. Custody and visitation will be addressed in any child support or any paternity or divorce case in which there are minor children. The parents can agree on custody and visitation, but if they are unable to come to an agreement, the court will decide based off of the child's best interest who should have custody and what type of visitation. The court will look at the fitness of both parents, meaning each parent's caretaking ability, their living situation, criminal history, the child's relationship with the parent, drug and alcohol abuse by either party, among other things. There are two types of custody that we will focus on. Legal custody refers to the right of a parent to make a legal decision for the child, where the child goes to school, what religion the child practices, decisions about medical procedures, etc. You can have sole legal custody, meaning one person makes all of the decisions alone, or you can have joint legal custody, where the parents work together to make these decisions. Physical custody refers to where a child spends their time. If you have joint physical custody, that means the child resides with each parent for a substantial amount of time during the calendar year. There is also sole physical custody, where the child lives mainly with one parent and the other parent has specific visitation rights. Many times you will see physical and legal custody lumped in together, and they will be referred to as sole custody or joint custody. Visitation can be ordered in many different ways. One is 50-50 time, which is where each parent has the child for a substantially equal amount of time. This may be week on, week off, or 3 days on, 2 days off, and rotating weekends. It just depends on the parties' decisions and the order of the court. Standard visitation varies from county to county, but generally it occurs every other weekend from Thursday or Friday after school or daycare until the child is returned to school or daycare the following Monday, and then you also rotate holidays. Standard plus visitation is standard visitation plus 1 or 2 extra overnights within the 2-week period, generally midweek. Supervised visitation occurs when there is an issue with a non-custodial parent that can put the safety of the child at risk. Supervised visitation comes in many levels, whether it's a friend or a family member supervising the parent when they're with their child, to a paid professional supervisor meeting the parent and child at a set location, or there's a private or DHS facility where the parent and the child both check in and they're monitored in a room during their visit. Suspended visitation generally only occurs in extreme circumstances. The last topic I will briefly discuss is child support. Child support is owed any time a child is not living with a parent, and parents are legally required to support their children up until the age of 18 or until the age of 20 if the child is still enrolled in high school. To calculate child support, the court looks at the income of both parties, the amount of overnight spent with the child, daycare, medical expenses, and many other factors. Child support can be taken directly out of your check through a wage assignment by mailing, or you can mail a check to the child support centralized registry, or you can pay at a kiosk in a store. You see them at 7-Elevens or grocery stores pretty regularly. Or you can make direct payments to the other parent. If you are going to make a direct payment, I recommend that you pay through check, and on the check's line you write child support for the month of December 2020. Make sure that you get a receipt signed by the other person if you're paying with money order or cash, and the receipt needs to say for child support for the month. You should not make direct payments to the other parent if there is an open case through child support services. Finally, if there's an issue of domestic violence in your case, here are some important resources that you can use to seek help. Domestic violence changes the way a family law case is handled, and it is important that you reach out to an attorney for help. It is also important that you are safe and well cared for. If you would like to ask legal questions or would like to apply for services, please feel free to call our application hotline or apply online. Thank you.